Thank you very much. Yes, thank you very much. We've spoken briefly before we put the cameras on in this matter. That was simply so that we could all understand how we're dealing with the matter, given that there is a draft judgment which has been distributed to all the parties, but which is currently subject to an embargo. And we've all agreed between us, or at least nobody's raised any oral objections, that the way we are going to deal with matter is that any references to the judgment will not be in detail, but by reference to the paragraph numbers, because in due course a fresh draft judgment will be distributed in absolutely the normal way to allow for the normal approach for typographical and other minor errors. I should say now we've probably got Mr. Coppell on the line that I'll repeat my sympathies for his position and my gratitude to his junior for appearing in his stead.
Well, I'm grateful. My substantive submissions, which I hope will be fairly brief,
yes,
are going to fall into three parts. The first is an overview and some brief points on the other forms of support that the court invited further submissions on. The second point, I'm taking these in reverse order. Second point is to address the court's third point in the email that it helpfully sent out last Wednesday, 4th of October, explaining how the Secretary of State puts the in-principle argument, as the court has dubbed it. And then the third point is dealing with the second point in the court's email, namely any case law on the in-principle argument. So far as possible, I will try and avoid repeating what Mr. Coppell said to you back in March, or indeed what we've said in our...
I mean, that is absolutely not the purpose of this hearing. We're very familiar with them.
Try and avoid.
And I can assure you we've all reread the submissions and everything that's been sent in since.
My lady, the court now has a number of documents in relation to the other forms of support that are or aren't available to persons who do not have a right to reside other than pre-settled status. You have the agreed note of the 4th of April, which sets out the forms of support from which such people are specifically excluded by a variety of statutory devices.
That's been described as Annex 1.
Yes, that's Annex 1. You then have, subsequent to the draft judgment, Secretary of State's further submissions, or further note of the 27th of June, AT's submissions in response, IMA's letter to the court, those both the 4th of July. I won't say anything further about the IMA letter, as that addresses matters that other matters that I'm not going to address you on today, and then the Secretary of State's response submissions. I just want to draw out from those exchanges a few points from the Secretary of State's perspective. The first is that there are a couple of issues on which the parties, as it were, agreed to disagree, because we considered that there wasn't agreement, but it would draw the court unnecessarily into some rather complex areas that they didn't need for your judgment. And those are in relation to the allocation of housing and homelessness assistance under Parts 6 and 7 of the Housing Act 1996, where parties agreed as to the outcome, namely that those with only pre-settled status are excluded from entitlement, but we differ as to how you get to that outcome, and there's no need for your ladyship and your lordships to settle that difference of route.
I'm profoundly grateful, because that in itself sounds like a matter for the Supreme Court.
The second point is in relation to mandatory reconsideration.
Yes.
And what matters a decision maker for the Secretary of State on a mandatory reconsideration is permitted to take into account,
yes,
insofar as those arise after the Secretary of State's decision. That was a point that arose in the original version of our 27th of June submissions, was disputed by Mr. de la Mare, and the dispute continued in our further submissions. On reflection, the parties are agreed that we don't need to invite you to settle that dispute. It would take you into some rather complicated territory in relation to Section 12 of the 1998 Security Act, Social Security Act, and the underlying regulations. This was not a case where the mandatory reconsideration decision maker took any of these relevant matters into account, because that decision predated the Court of Justice's decision in CG by a number of months. So it is, for purposes of this case, academic. The second point is that, and I think this may be a source of some of the disagreement between the parties in their further submissions. The Secretary of State attempted to answer the exam question that the court set it in its email of, I think, the 19th of June, looking specifically at the position of AT as at the date of her claim. That's not quite the exam question that's asked by Section 12 of the Social Security Act 1998, which is a point that we've set out in our submissions. And we thought it important to point out that contextual point. We also, and again, this was objected to by Mr. Lemaire, but I hope we quite clearly set out what we were doing. We also looked at some of the wider issues, because at times the court has referred to persons in AT's position, which could be interpreted more widely than person literally in exactly her position making a claim at exactly the time that she made it. Persons in AT's position could include anyone with pre-settled status as their only right to reside. And for that reason, we pointed out that there were other forms of support potentially available to such persons. Obviously, each of those will have their own entitlement and eligibility conditions, which may or may not be met by a particular claimant. But we thought it right to identify that to the court, so the court didn't get the impression that the support that was potentially available to AT was the absolute totality of support available to persons with only PSS. We also we have set out our response to the so far as the points of dispute in some detail in our further submissions of the 10th of July.
Yes.
We accept that there was no, we're not saying that AT would have been subject to disability-related benefits. There was no claim for such benefits and no assessment.
We did have many, many pages about disability benefits and carers benefits.
Yes.
And I wasn't wholly clear why we had such detail about those, given that no one suggested for a moment they had any relevance in this case.
There may be cases that are, as it were, quite closely related to this case factually, where they would be relevant. But I take your lady's point, and I won't labour it further. We stand by the points that we make in our written submissions of the 10th of July. Another point where it seems to be there's criticism from AT is that really the criticism appears to be one about the sufficiency of the forms of support. We didn't understand that to be the question the court was answering. Some of the issues of sufficiency were addressed by the First-tier Tribunal, which made findings of fact which are not or no longer challenged here. We fully accept that the main form of support in circumstances such as the claimants that would have been relevant is support under Section 17 of the Children Act. And Mr. Coppell addressed you to a considerable extent on that. There are other forms of support. We say that they are relevant. For example, support with health costs under the NHS, and so on, support with free education provision had Section 17 support been available. So that is why we set out quite carefully what we said the forms of support that potentially were available to AT, and potentially available to others in slightly different factual circumstances, potentially including AT at a future date.
Just tidying up, if I may, your Section 17 submissions, which you set out. As I understand it, the Secretary of State accepts, first of all, that the local authority don't have an obligation to provide for the needs. They only have to assess them, and that's the first point. And the second point is that I think Barnett makes it clear that the local authority are perfectly entitled to take into account their budget constraints.
Well, subject to the fact that discretionary powers, as Section 17 is, can crystallise into duties.
Of course.
And we would emphasise that point. It's something
Can I just ask you about something flowing from that, which I think I understand, and really only just want you to clarify yes or no. As I understand the Secretary of State's submission, if what's described as a framework is adequate and covers the situation of a claimant, such as AT, that is sufficient for the defence to a claim for violation of fundamental rights.
I'm just about to address that under my second.
Right. The converse is, let's assume for the sake of argument the framework argument, the in-principle argument is valid. There may be two alternatives of it. One which is, if you like, purely theoretical. There is a statement of law which covers this case. The alternative is there not only has to be a statement of the law, but there needs to be some proven capability so that it can be applied, which may result in an examination of resourcing. So that we just really want you to clarify. We're not looking for a detailed exposition. We just need to know which it is. We understand it to be the former. It's the pure framework, because that's the way it's expressed in the various submissions we've received. That's as we understand it.
Yes. If perhaps that is a convenient moment to move on to the second topic, which is addressing the court's question in its email about clarification of our position on the in-principle argument.
Yes.
So the court asked the question, as presently described in the new written submissions, what matters for there to be a defence to an allegation of breach of fundamental right is the existence of a set of laws which by their scope alone cover the situation of the claimant. Is that correct? The short answer is yes, that is basically correct, subject to the important caveat that those laws need to be enforceable either through the courts or the tribunals. We note that the label in-principle argument, I think, is one that was adopted by or coined by the Upper Tribunal. It's not necessarily one that the Secretary of State would accept as a particularly apt description.
How would you describe it?
We say it's simply respecting the legislative framework that's been put in place by Parliament, which is not a terribly snappy way of, not a snappier way of putting it. But my submission is more accurate. I mean, if I can just sort of summarise the Secretary of State's position, I hope fairly briefly. I think the first proposition is that where it properly arises, the obligation on a member state, or in this case an ex-member state pursuant to the withdrawal agreement, to comply with the Charter, and pausing that, just obviously all this is said without prejudice to our ground.
Understood.
Where the obligation falls on the member state. Second proposition, as a matter of EU/withdrawal agreement law, how a member state allocates functions internally is a matter for that member state and its domestic laws. And that's entirely consistent, we would say, with, for example, the description of social assistance at paragraph 68 of CG. I can take your ladyship to that, but I think...
I doubt there's any dispute about that in the broader sense, that implementation is for the state, and it has a discretion as to how it allocates responsibility intra-state.
Yeah, and it's also consistent with, we would say, with what the Court of Justice says at paragraphs 92 and second subparagraph of 93 of CG. Third proposition, there are, as we've sought to set out in the various notes and submissions, various forms of support in cash and in kind available from a range of public authorities. Those include, obviously, the Secretary of State, but also local authorities, Department for Education, the NHS. And a number of those, as we set out in the note, are potentially available to EU/EEA citizens who have only pre-settled status. Fourth proposition is that Parliament has determined the relevant means of enforcement in respect of entitlement to such support. In some cases, that will be the First-tier Tribunal and the tribunal system. For example, benefits administered by the Department for Work and Pensions, tax credits administered by HMRC. In some cases, it will be county court in relation to housing and housing assistance. And in others, it would be the judicial review jurisdiction of the High Court. Fifth point is that where Parliament has allocated a function to a public authority...
Sorry, can I just clarify?
Yes.
In earlier submissions, there was reference to ombudsman being adequate, an informal, non-judicial method of... Do you
I wouldn't resile from that. That meets the accusation that the High Court is very expensive and difficult, that there is also an informal means of resolving disputes.
Also, or instead of? Is it supplementary?
It's also. I mean, one has. I think one.
If it's supplementary to a judicial system, then fine. If it's just there and it exists to supplement something. If it is standing alone, said to be adequate, regardless of a judicial system,
it supplements.
Supplementary. Okay, that's all.
A party will be under a duty probably to bring a complaint because of the discretionary bar that arises in judicial review, where there's an alternative remedy. But then there is exclusion between the ombudsman and court cases. So a party or claimant will have to make a choice as to whether they pursue the routes. But it is a supplementary one if they don't want to engage in the complexity of court proceedings. They can potentially go to the ombudsman and claim for malefactor.
I doubt there's an objection if it's purely supplementary. It's a quicker and easier method of getting relief. If it were a substitute for a judicial system which met any test of efficacy, then I'm not certain you're saying that you would treat an ombudsman as an adequate solution.
No, I'm saying it supplements.
Okay, understood. That's very helpful. Thank you.
Fifth proposition, where Parliament has allocated a function to a public authority other than the Secretary of State, the Secretary of State, in making decisions in respect of the discharge of his functions, is entitled to proceed on the basis that that other public authority will act lawfully in just discharging their functions. I'll come on to, under the third topics, a couple of cases relevant to that point, but I'll leave that till slightly later.
Can I just ask you one point on that?
Yes.
If in reality, on the findings of fact made by the FTT, she was destitute, she shouldn't have been, but she was, and then she makes a claim against the Secretary of State, why does she then need to go through a failed legislative system?
Well, it hasn't been failed. It hasn't. We would say it hasn't. The relevant remedies have not been fully pursued under that system. The fact that a public authority may have failed to discharge its duties doesn't mean, we say, that duty then switches to another public authority.
And the public authority you say that failed in this case was the local authority?
Well, we say that there's we say that the respondent faces a dilemma. Either this is a case where her circumstances were such as to amount to a risk of breach of Article 1 and Article 4, potentially in Article 8 of the Charter, or the equivalent provisions of the Convention, Articles 3 and 8. In which case, her remedy was to argue that there was any discretionary power of the local authority had crystallised into a duty to avoid those breaches, and that should have been pursued by way of judicial review or challenge to local authority. Or the situation is not one where there is a risk of such breach, in which case there was no unlawfulness on the part of the local authority, but also could be no unlawfulness on the part of the Secretary of State. The point is that by either route, you don't get to a situation where the Secretary of State is required to pay universal credit in a manner that is not foreshadowed in relevant legislation.
Well, it needn't necessarily be universal credit. It's just enough to ensure that she is not destitute. She asked for universal credit because that's what the benefits people know about.
Yeah, but my point is that Parliament has established certain functions and established certain benefits, and those are the functions that the Secretary of State is required to discharge.
In running this argument, if this was sort of at the heart of your argument, was consideration not given to joining the local authority? Because what you now seem to be saying is local authority, they're completely on their toes, nothing to do with us.
Well, I don't
in which case, I'm just not sure why the local authority won't join, because they might have something to say about all of that.
Well, I mean, that's why I put the argument as in the form of a as it were, a dilemma, rather than saying it's one or the other.
Particularly what we know in the real world, as opposed to we won't call it in principle world anymore, framework world, what actually happens so far as Section 17 is concerned, and the facilities and the money available to local authorities so far as Section 17 is concerned.
Well,
I mean, how unrealistic do we have to be?
Well,
I mean, that's a genuine question. I mean, because we have to just look at the framework and set aside anything that we know from authorities or anything else about the effectiveness or otherwise, or the ability of local authorities to provide for needs under Section 17.
I don't. In my submission, you don't have to be unrealistic at all. It's a question of the functions that Parliament has ascribed.
So we just look at the framework.
Yes.
So we ignore what effectively is common knowledge about the state of Section 17.
In terms of yes,
this really isn't a trick question. I'm just, it's tricky. It's very difficult.
In my submission, yes, I mean that is the framework that Parliament has established. There are mechanisms for enforcing it, and avoiding breach of convention and charter and coextensive charter rights. And it's not making a finding in a case like this that the claimant is entitled to UC.
Well, I think, as my Lord Justice Dingemans just said, that it doesn't have to be universal credit, does it?
No, or some other.
Because we know on the authority. Sorry.
Yeah,
we know from the Section 17 authorities that actually the relatively modest amount of money, significantly less than universal credit, that can be given to failed asylum seekers can be adequate. So we're not necessarily talking about universal credit.
Yes, but that would be an extra statutory form of benefit that Parliament hasn't set up, and Parliament has identified where there is a family with children, that there is a discretionary power which, as I say, can crystallise into a duty in certain circumstances that can address those needs.
Thank you. That's most helpful.
I'm sorry, we're going to keep badgering you a little bit.
No.
In one of your earlier submissions, you addressed the issue, which I think you're just focusing upon, which is you said that we haven't addressed in the draft judgment the situation which arose because the local authority only answered the question which was before it, i.e. refuse or grant UC. And so the question arises as to who bears the responsibility of putting, as it were, the right case in front of the local authority. And the CJEU in CG can be construed as saying that when an authority refuses universal credit or a benefit applied for, it then has the proactive duty of ensuring or ascertaining or checking whether some other form of benefit is available. So are you saying that the local authority, even if it was right on the wording of the regulations to refuse UC, was entitled to just say, that's it? Do you accept that they had a responsibility, or the state has a responsibility to, I'm using the words in the judgment, ensure, ascertain or check, which is paragraphs 89, 92 and 93 of CG. The duty remains on the state to work out for itself what the person in need is entitled to. Do you accept that, or do you, because I think everyone accepts that wasn't done. The question was put to the local authority, UC please. Answer, no, you're not entitled. Didn't then go on and proactively say, what else?
Sorry, the local authority wasn't asked to grant.
No, you're quite right. The Secretary of State.
Secretary of State, yes.
But the state as a whole, though, whether it's
yes.
central or local, the state has a responsibility thereafter to ask itself what is the entitlement in law of the applicant for benefit. Not UC, something else. Who, in your case, is the duty upon?
The duty is upon the public authority that is allocated the relevant function by Parliament. In my submission, in this case, this is not a case, as this is someone who doesn't have pre-settled status and is on the face of Regulation 9 of the UC regulations not entitled to universal credit. It was for the local authority to make an assessment, bearing in mind that this claimant wasn't entitled to universal credit. That's the way Parliament has allocated functions. I think this is a point that Mr. Coppell made back in March.
It is, yes.
That otherwise you end up with a sort of after you kind of situation. Parliament has set out the functions, and
yes.
those
for my part, I've got no problem with the state having the ability to allocate appropriate responsibilities. Across the EU, when we're in it, there are a vast range of different federal, non-federal systems under which responsibility for social care and need was allocated. So that's the state's discretion. But the question arises within that scheme of discretion, and I think you accept that it remains the responsibility of the state to determine in relation to AT what her needs are. You say it's for the local authority, not the central state, but you accept that there is that responsibility on the state. She doesn't have to then go and search her way through all the textbooks and the regulations to work out what alternatives there might be that she could ask for. You have to get out your latest submissions and work through that list of framework or in principle benefits and say, I think I'll have that one at paragraph 17 and that one at paragraph 28.
I'm not sure I agree with that. I mean, the state sets out through Parliament a legal framework that through which benefits are allocated, and sometimes that is of some complexity. But claimants ultimately will need to know which benefit suits their circumstances. There will obviously be guidance and so on from the state, but I'm not sure. I don't think I accept that the point that your lordship's making.
So I think we need a quite clear answer on this. So in your submission, it was the responsibility of AT to say to the local authority, I'd like the following benefits. Not the responsibility of the local authority.
It was the local authority, once it was presented with AT as someone with a child who was in the circumstances she was in, to carry out a proper and lawful assessment of her. Now, obviously that process may be assisted if AT or those representing her are able to say, actually she should be entitled to this. But the bit of the state that is tasked with that kind of assessment under the relevant legislation, it is the local authority. So,
I'm sorry, that seems to be inconsistent with the answer you just gave me. So what I want to know is really very simple.
It depends what you mean
if
by
you like,
state.
in legal terms, who's got the burden of proof of establishing the entitlement? Is it a Romanian immigrant with a child, or once, as you say, AT's presented herself to the authority, have they got to work out from their plethora of different powers and so on, which are the most appropriate for her? Is the duty on the state, however it's allocated, proactive as well as passive? And the reason I ask is because after the draft judgment, we said that we hadn't addressed the question, which was that the local authority and the Secretary of State had not been asked to address anything other than UC, to which the answer might be, well, the European Court in CJ said, well, it's for the local authority, or the state as a whole, to work out, using the words ensure, ascertain, check, what the alternatives are.
Yes, and that in part of well, I think part of the ascertaining, I do say that the language in relation to ascertaining has to be understood in the context. This was a decision being directed to the referring tribunal, and in that context, it was for the referring tribunal to do the assessment that the court had identified. But the allocation, I'd go back to my point that the allocation of functions is by Parliament. Ultimately, yes, it's for a claimant to show that they meet the relevant eligibility conditions and that they are entitled to whatever the relevant support or benefit is. Now, there will be a public authority will once presented with the claimant need to investigate the situation so that they can make a lawful decision. Sometimes that will be specifically codified in relevant legislation. Sometimes it will simply be a discharge of the public authority's Tameside duty in order to be able to make a rational decision. I don't think that's not imposing some impossible burden on a claimant.
So in black and white terms, what was AT required to place in front of the authority? What was she required to tell them? Was she entitled to simply say, here I am, this is my scenario, my predicament, full stop? Or did she have to say, here's my scenario, this is my predicament, and I have rights under the following A, B, C, D? Which of those two? Because they reflect very different burdens of proof.
I think it would be the first of those. Ultimately, the local authority knows the statutory toolbox it's got available. Now, it may be that the claimant is able to assist local authority by saying, by the way, I think it's going to be this support. Obviously, some claimants will have support, some won't.
Absolutely. I don't suppose anybody quibbles with that. If you know the law, then fine, you can make your case. But if you are an indigent applicant in need, you just simply say, most people are going to say, here I am. And that sort of makes sense. I mean, the local authority are the experts.
Yes, I mean, there's a little bit of discussion of that in the claimant's, in the respondent's witness statement, and that of her support worker, dealing with what was, and some findings in the FTT decision. And as far as we can see, one can surmise that the local authority was told the essentials of her case, that she had limited other resources and had a child and
yes.
had various health issues.
Yes.
I don't think there's any reason to doubt that
yes.
in this case.
Yeah.
What the local authority then did with that information, it appears that they decided that she didn't meet their criteria. Whether that was a lawful decision is
yes.
is
I understand all of that. I'm really just trying to be clear as to what the basic principle, where the responsibility lies. And you've said that it's open to her, as it were, to present herself and say, here I am, this is my crisis. And thereafter, and I think prima facie this is consistent with the court in CG, the state in the broader sense, wherever responsibility is allocated, has a duty to check, ensure, and so on. I understand you to accept that in broad terms. Thank you very much indeed. That's very helpful.
But the right bit of the state.
Absolutely. I understand your concern about that. I don't at the moment see that that's the issue in this case. All states are entitled, prima facie, to allocate responsibility as they wish. I mean, then it becomes a question making sure that the system is effective in some appropriate way.
Now, where have we got to?
My sixth. Yes, I was actually halfway through my fifth submission. Where I said that Parliament allocates functions, the Secretary of State was entitled to make his decisions in respect of discharge of his functions on the basis that other public authorities will act lawfully in discharging their functions. And that discharge, as I said, includes discharging their functions so as to avoid breach of either the Convention or effectively coextensive rights under the Charter or EU fundamental rights. Sixth point proposition is that the Secretary of State is entitled to proceed on the basis that if another public authority fails lawfully to discharge its functions, then that is a matter that can be corrected by a court or tribunal, not by the Secretary of State, acting as a default provider outside the functions allocated to him by Parliament.
So the proper course in this case would have been to judicially review the local authority.
Yes, or to make a complaint under the statutory complaints procedure.
Can we just explore the theoretical underpinning to that? So far as an individual is concerned, let me put the proposition, I think, which we'll put against you, that so far as the individual is concerned, that individual is entitled to a remedy against the state. It's a matter for central government as to how it wishes to allocate responsibility, but it must ensure that the responsibility is implemented effectively, one way or another. So if there may be an instant failure by the local authority, and I think this is the basis upon which this case is brought, there may be a failure by the central government to ensure that the system works properly, because you have ultimate responsibility for ensuring the system works. That's why the Secretary of State was made a defendant.
Yes, but there is that one can only reach that view if the relevant enforcement mechanisms that the state has set in place have been tried and those have failed. They were not in this case.
Just what part did this submission play in the FTT and the Upper
Tribunal? We very clearly made the submission that if the local authority had failed to discharge its duty,
wasn't your fault, and
it's a matter. I think there's the.
No, it's fine. Don't take me to it. I'm just.
I won't take. I think Miss Smythe pithily summed it up in the submissions to the FTT when asked about this. Said that's not the point. That submission is recorded in the tribunal's decision. So that was very firmly our position.
Without the local authority being given notice of that.
Well, the local authority wasn't joined as a party. It was the FTT proceedings were fairly heavily expedited.
Because she was destitute. I mean, I know we're talking about these possibilities, but the here and now was the finding of fact, rightly or wrongly challenged anyway, it's a finding of fact that binds us, that she was destitute. And then she goes and asks the First-tier Tribunal to sort it out. And you say, well, you now, as I understand it, accept whether under Article 1 or whether under the common law duty of humanity or whether under the European Convention of Human Rights there's a duty to provide to ensure she's not destitute, but it's just that she's asked the wrong person, wrong tribunal to help her. Is that it?
Yes.
Yeah.
I think that
No, I thought that was...
I'm not ashamed of that answer.
Yeah.
That's the way Parliament's allocated the relevant functions.
Yeah.
Sometimes that happens. I mean, claimants go to the wrong.
So the tribunal should have refused jurisdiction.
No, they should have considered the matter, but on the point, they should have accepted our submission in relation to the legal position on section 17.
Thank you.
And in terms of, so she should have, in your world, she should have proceeded by way of judicial review. And she would have had, in order to succeed, even with super expedition, 3, 4, 5, 6 months later, have established that the framework was inadequate. Because as you say, that's your defence. In principle, the framework was sufficient. She would have had to have established that on a judicial review, that the system was not adequate. The framework was not adequate, it was inadequate. And only if she had won that would there then have been a finding of breach of the convention, or breach of any fundamental rights.
I don't think, I didn't think that was quite what you were saying.
No,
I think what you were saying is she would be attacking the local authorities' decision that made under Section 17 not to provide whatever housing, money, whatever, as an unreasonable decision.
Then how does judicial review fit into it? Do you accept that? Do you say that judicial review was the route she should have pursued, or was not the route she should have pursued?
If she was dissatisfied with the local authority's decision, which if she's destitute, then
Well, that's a finding.
yes.
It is the finding. We can't
But
go behind that.
the local authority, yes, she should have challenged the local authority's decision
So,
in respect of section 17.
So, if we just sort of think of it almost like a timeline, what you say is she applied for universal credit. That's set up by Parliament. You have to fulfil the various criteria. She didn't fulfil those criteria. Therefore, quite properly, that she was not granted universal credit. Question, what else would she be potentially able to have for your framework? Well, you say the key thing that she would have been able to have was under Section 17 of the Children Act.
In this case, yeah.
You say that they, for whatever reasons, offered her some tokens, and we don't know what the criteria were, but they said they didn't meet the criteria. So she got no support there, and so she remained destitute. What she then did was go to the First-tier Tribunal on an appeal against the granting of universal credit. You say that she should not, that was the wrong route for her to take, given where she'd now got to. However, the First-tier Tribunal was right to accept jurisdiction, notwithstanding that it was the wrong route, but the tribunal should have dismissed her appeal against universal credit on the basis that she should properly have gone through a judicial review route in relation to the failure of the local authority to meet her needs through the route of Section 17. Have I got there? Yeah. Yeah? Seeing nods?
Yes, I mean, yes, I mean, the correct...
I mean, I think that's your case.
The allocation of functions is that these particular needs could and should be addressed by the local authority. And the First-tier Tribunal should have recognised that, and we say the answer is that when they did that, they would have been bound to come to the conclusion that we were right.
Can I just ask one question on this? Because obviously the duty to litigate it comes in other areas of law when you're talking about mitigation. She had asked for child benefit, and she had got £40 and a present or something like that. They hadn't given her more. We now know on the findings of fact by the FTT that they were wrong, if you're right, that the power had transformed into a duty. Does she have to litigate against the local authority, or can she just turn to you and say, look, you've set up this system, it hasn't worked for me, I'm destitute, now give me whatever you want, I want universal credit, you can give me the equivalent of what asylum seekers get, as long as I'm not destitute?
No.
You say there's a positive duty for her to litigate to achieve the result?
Well, there's not.
Because that's the only way she's going to get it, once she's applied and not got it, because she had applied to them. It wasn't as if she hadn't applied to them. She had applied to them and not got it. So you're actually contending that the existence of that other remedy, until she's exhausted it, means that she's under a duty to pursue it.
Well, she's not under a duty to pursue it. The state isn't in breach of the chart. The Secretary of State powers are not to be, powers and duties are not to be reinterpreted in light of the Charter. If there is an alternative, the alternative route established by Parliament is still there and has not been fully used.
Well, so in effect, there's then her duty to pursue that alternative remedy. Otherwise, she can't show that she's truly destitute because she has this theoretical action. And what about all those authorities about in other areas of the common law, which is you're not under a duty to sort of embark on speculative action to mitigate losses?
Well, this is in my submission. This is entirely consistent with what the court says in CG in respect of entitlements. If someone is entitled to other forms of support, even if they're not being given them, they still remain entitled, and it's that entitlement that they can potentially vindicate through a court.
Is entitled the right word under Section 17?
Well, if it's the case that her situation was one where non-provision of support would result in a breach of either Charter or Convention rights, then it would seem to follow that would be a case where there was the discretionary power had crystallised into a duty.
Right, so we've got your sixth.
Sorry, there was just one point. My Lord Justice Dingemans said that we were bound by the finding that she was destitute. I mean, I should say that is subject to our fourth ground, that the FTT and the Upper Tribunal were wrong about the threshold.
Yeah.
Which we don't in any way desire from, but I'm not going to address you on that now. So yes, I mean my seventh point was the one that I've actually just already alluded to. That in my submission, that's entirely consistent with the wording of the Court of Justice in CG. May actually and currently benefit and are actually entitled to benefit. The focus there is on. It doesn't say does actually and currently benefit. It says may actually currently benefit, and it refers specifically to entitlement. So, in my submission, the court was saying that the particular public authority concerned with granting social assistance is entitled, is allowed to look at other forms of entitlement the person has under the domestic legislative scheme. And final point, and I think this is one that I won't take you to again because I think Mr. Coppell addressed you to, but this isn't, in my submission, unorthodox territory. The Supreme Court, albeit obiter in HC, recognised that judicial review, for all its faults, was an adequate way of enforcing Section 17 of the Children Act to give effect to Zambrano rights. And our submission is that's no different with Charter rights. So we say that to characterise the argument as an in-principle argument somewhat underplays the reality, which is it's an argument that recognises the proper functions allocated by Parliament to various public bodies. Moving then on to my third topic, which is to address your report's second point about whether there's any case law on the in-principle argument. The court has helpfully referred to the case of DSD. That was a case in which the Supreme Court upheld the judgment of the Court of Appeal, dismissing an appeal by the Commissioner for Metropolitan Police against the judgment of my Lord Justice Green when he was a High Court judge, allowing victims of a rapist, Derek Warboys, for breach of the investigative duty under Article 3 of the Convention. In that case, the court was unanimous as the outcome, but divided on whether the positive obligation would be breached only by systemic or structural failings on the one hand, or by systemic and operational failings on the other. Lord Hughes took the former view, whereas the rest of the court took the latter view. We don't consider that DSD sheds an awful lot of light, if any, on the in-principle argument for a couple of reasons. The first one is that the Supreme Court's analysis in all the judgments is very much focused on the particular jurisprudence in relation to Article 3 of the Convention. And this isn't primarily an Article 3 case. Second point is that this was a case concerned with the duty of one particular public authority and the scope of that duty and the extent to which failings by that public authority could amount to breaches of Article 3 of the Convention. Whether they had to be systemic failings or could be operational ones as well. As I hope is clear from my explanation of the in-principle argument, that's very much focused on the allocation across between different public authorities and legislative decisions made by Parliament. That wasn't an issue in DSD. We have copies of DSD if the court would like.
We've got them.
Got those.
We have them, but thank you.
We have investigated further, and there are two cases that potentially shed some light on DSD, which I will.
We had rather been hoping, in the light of our note, that we would have been given advance warning of any cases.
Yes, I'm sorry.
Have all the other parties had these cases? An opportunity to consider them?
I'm not sure. I don't think. I'm afraid we don't think we did. I apologise for that. The two cases are Munjaz.
Copies for us?
Um,
Are they sidelined so that those people that haven't had an opportunity of advance notice can flick through them and find
the relevant passage is paragraph 114 to 115 of Munjaz, which actually then quotes the relevant passage from the second case, which is Adlard. Well, 114, 115, Lord Brown.
I think, just before you move on, if you're going to ask everyone to look at this, I think you better just all read the head note.
Yes, that would be helpful.
Yes, thank you.
My lady, as I'm sure you know, Mundaz was a case about a judicial review challenge to the lawfulness of guidance adopted by Ashworth Special Hospital in relation to the seclusion of patients, which differed from the code of practice promulgated by the Secretary of State under the Mental Health Act 1983. One of the arguments that was advanced it is set out by Lord Brown. I should say that Lord Brown was in the minority in the outcome on the point. However, on the point that I'm going to take you to, the rest of the majority of the court agreed with him. We see that from Lord Hope's judgment at paragraph 98. The opening lines of that, page 212. I'm in full agreement with all my noble and learned friend Lord Brown of Eton under Hayward has said in this case, except with regard to the issues raised by Article 8.2 of the Convention. And similarly, Lord Scott at 101 on the following page, where just below F, he says, I'm in respectful agreement also with everything that my noble and learned friend Lord Brown of Eton under Hayward has written, save in relation to Article 8 of the Convention. Now, the argument that Lord Brown was addressing was summarised at paragraph 112, his judgment, page 216. That the Code of Practice issued by the Secretary of State had to be given an elevated, enhanced status in order to secure compliance with Article 3 by the state. He then went on at paragraph 114 to reject that argument, 114 at the bottom of the page. He said there can be no principle that the state is obliged to promulgate a code whenever the risk arises of public authority acting incompatibly with the Convention right. And then over the page he added a further argument, which is the one that I particularly want to rely on here. There is, moreover, to my mind, a further ground for rejecting the Article 3 argument here. As I observed in my judgment in the Court of Appeal in Adelaide, again, it gives the citation, Secretary of State's obligations under Section 6 of the Human Rights Act is not himself to act incompatibly with the Convention right. He is not obliged to ensure that other public authorities themselves act compatibly. And then further on in that paragraph, I see no reason, however, why that same principle should not apply equally in the present context. Secretary of State is entitled to place the responsibility for acting compatibly with Article 3 on another public authority, here the Hospital Trust. Now, we've also handed up, for completeness...
Can I just ask you about the paragraph sentence in 114?
Yes.
When Lord Brown says the Strasbourg jurisprudence goes nowhere near supporting such a principle. Even in an Article 2 case, the positive obligation arises only in cases where the state knows or ought to know of a real and immediate risk to life. Is that an exception, even on Lord Brown's formulation? So if there's absolutely no reason for the state to know there's a problem, and it promulgates clear, unequivocal, adequate guidance, and the local authority breaches, then it's not a breach by the state, it's a breach by the local authority. If the state is aware that there is or might be inadequate enforcement, is he saying that a duty then arises under Article 2?
I think he's leaving open the possibility in relation to Article 2. I mean, the main point I'm seeking to rely on in this judgment is the one in the next paragraph about allocation of responsibility. I'll just finish off by presenting the authorities. As I say, the second authority is Adelaide, which for completeness we've provided. That was a case in which a judicial review was sought of a decision by the Secretary of State not to call in a planning application in relation to the renovation of the Fulham Football Club ground. And one of the grounds that was advanced was that the Secretary of State should call it in because otherwise there would be a breach of the objector's Article 6 Convention rights. That was an argument that was rejected by the court. Lord Justice Simon Brown, as he then was, gave the lead judgment. He dealt with this argument, which he accepted was technically moot, as one sees from paragraph 33, because of the court's finding on the first issue. He deals with it at paragraphs 36 and 37, rejecting the argument that the Secretary of State was required to call in order to safeguard Article 6 rights. The rest of the court agreed with him on that. We can see that Lord Justice Mummery at paragraph 45, at page 2532, and Lord Justice Dyson at 46. And that is the source of Lord Brown's, as he then was, statement at 115 of Munjaz. And the Court of Appeal in Adlard adopted and approved Mr. Justice Ousley's reasoning in the case of Cummings, which is set out at paragraph 37, which I'd invite you to read.
How are we getting on?
We're
Having said that
very,
2.5 hours was
done.
far too much, we're now in danger of significantly cramping the style of the other parties.
My lady, I hope I've got about another 2 or 3 minutes. So we would accept that these were cases where the Secretary of State had a particular power. In Munjaz, the power to issue a code of practice, and in Adlard, the power to call in a planning decision. So that's different from the present case, but we say that actually it's a fortiori where Parliament has allocated functions, that the same principle applies, that the duty doesn't fall on the Secretary of State because another public authority may or may not have protected the convention rights or charter rights of another. We also accept that both these cases were cases about convention, but we say there's no reason why the analysis should be any different under the charter. So we haven't been able to find anything else on point. That may be because we would suggest that actually the point is relatively uncontroversial and obvious. But those are my submissions, my lady, on the points I was hoping to address you on.
No, thank you. Thank you very much indeed. Yes, Mr. Dingemans.
We get to that end point, my lady. I can't help feeling like Dorothy in the Wizard of Oz. I have a feeling, Toto, we're not in Kansas anymore. This case is about the application of the judgment in CG and about the application of the test, primarily the test contained in paragraphs 92 and 93, fixing an obligation on a party effectively in the shoes of the FTT, the UT, when deciding upon a benefit question. And it was for that reason that this court naturally focused upon the question that does seem to arise from those passages, which is, what are AT's actual entitlements? That was the question that was asked. That's what generated the supplementary notes to detail the alleged entitlements. The way we've got to in relation to that question is basically as present. There is no entitlement that AT has that will address her indigence, her destitution, head on, beyond the alleged entitlement under Section 17 of the Children's Act. That's the only show in town, so far as the Secretary of State is concerned. In other cases, there may be the potential, if you have the requisite disability, to seek DLA, etc. That's not this case. And in the background, there are state benefits that are provided, or state assistance, that, if you like, gnaw at the edges of the problem, like the availability of medical assistance or childcare. They don't address the problem of indigence, poverty, destitution head on. That's the general framework. There is only effectively the Children's Act, where it may apply, and DLA. One can immediately see the poverty of this argument for someone who, for instance, doesn't have a child. A victim of domestic violence in a refuge with no children, may be heavily pregnant. No Children's Act analysis possible in those circumstances. No DLA analysis possible unless they have a disability, which is less likely than not. So that is, with respect, the backdrop for this argument. It is an adventitious argument that doesn't address the problem head-on and hasn't been helped, and we've used some fairly pungent language in our submissions, it hasn't been helped by the barrel scraping of the things that are pointed to by way of state assistance, some of which substantially, factually post-date the events in this litigation, or some of which really require a fairly fanciful construction to anyway take credit for the state for the fact that the police direct you to a refuge, for instance. That really has nothing to do with the price of fish. And so then we're left with this in-principle argument, as it's described, the Section 17 Children's Act argument. Now that argument has been run throughout. It was addressed very fairly and squarely by the First-tier Tribunal and, importantly, by the Upper Tribunal. And the Upper Tribunal's approach to it in our submission was absolutely on the money. They said AT did everything she could to bring her position to the attention of the local authorities. She pressed her case. All she got was some shopping vouchers, at which point her file was closed. There was nothing more she could do. And that shows what the position is for the purpose of applying the test the CJU has set out in section 92, paragraph 92 and 93 of its judgment about actual and current entitlements and assessing her position. Those are the resources to be taken into account and no more. And what may be theoretically available is nothing to the point. And in that respect, the Upper Tribunal is entirely correct in its application of the CG test. And the reason why they're correct is for reasons of principle, because the state can allocate functions as between itself. That's perfectly permissible as a matter of EU law, so long as those arrangements operate to discharge the obligations of EU law that are fixed upon the state. That's a debate as old as the hills in EU law terms. It's a debate that's played out in Frankovich claims as to whether or not the state's entitled to say local authority pays the bill versus central government, a case like Hain and Austria, etc. But what is not possible is to pass the buck on the eventual obligation of result. Why? Because that flies in the face of the ultimate linking principle in all of this, which is the principle of effectiveness, the principle of effective protection. And this isn't a new argument on our part. We cited the key case on remedial fracturing and effective remedial protection in the CJU's case law at paragraph 63 of our skeleton arguments, a case called Impact, which says, yes, a member state is entitled to send you off to different places for different remedies in principle. It's permissible, for instance, to say you must go to an employment tribunal for these purposes and to the High Court for those purposes. You have a remedy here for this part of your baggage of rights and a remedy here for that other part. That's permissible so long as that regime complies with the principle of effectiveness, of effective remedial protection. And that's the rock on which these Section 17 submissions founder in my submission, because the argument made by the Secretary of State is an argument that has no correspondence with reality. It has no correspondence with the reality of the facts of this case, and it has no correspondence with the reality of how Section 17 of the Children's Act operates in practice. Section 17 is a target duty. it is a target duty of considerable limitation, not least because, unlike the readily accessible tribunal service, there is no medium for finding contested fact. Yes, we're dealing with an established fact here, the destitution of AT, but it's only been established because she had the ability to access the tribunal system. It's the very type of topic that would be potentially hotly contested in a judicial review, and as to which the court may find a decision maker has a substantial evaluative discretion, even before one gets to the substantive discretion issues. So that's the first problem, access to fact-finding. And the second problem is, of course, the entire burdensome nature of the process to establish entitlement by judicial review, against which all the Secretary of State can do is point to the parallel route to redress through an ombudsman. And those processes are also notoriously time-consuming. And this is a backdrop of a case that is concerned with the fundamental question: how can this woman and her child live in dignity in extremely trying circumstances? How can she have sufficient money to eat properly, given her medical needs? How can she have sufficient money to treat her child in accordance with their best interests, so that they grow up and develop in circumstances other than abject poverty? That's the immediate pressing need that has to be addressed. And the idea that judicial review or an ombudsman process, presumably she's meant to access interim relief in a judicial review to get interim payments or some form of expedition. The idea that that provides a remedy is unreal, and it's particularly unreal.
Is legal aid available for that sort of remedy?
It is potentially available, yes. It is potentially available. But obtaining interim relief in those circumstances is going to be a formidable challenge. Obtaining permission can be a formidable challenge in and of itself, and these claims are contested. And then you come across the rock of resources, as my Lady Justice King has pointed out. All of this is bounded by the resources available to any particular local authority. And it's a matter, I think, of which you can take judicial notice, that in certain parts of the country, the demands made upon local authorities under Section 17, because of the presence of asylum seekers with their particular needs, or because of the presence of people who are lawful immigrants. For instance, Afghans with indefinite leave to remain under the Arab scheme. They come to the UK, they're entitled to be housed, and their children have priority needs under the Children's Act.
You clarified this morning that resources are not a relevant part of the Secretary of State's defence. That's been part of the focus of our questioning, to understand to what extent the defence relies upon the system being funded. So the Secretary of State would say, even if it is the case that the Children's Act is not properly funded, it makes no difference. It's still a defence.
Well, that's the argument the Secretary of State makes.
Yeah.
But the answer to that is that's not an argument that the CJEU would accept as being a permissible argument under the test under Section 92, or paragraphs 92 and 93. And administrative resources, or the impact on administrative resources, are a notoriously hopeless argument in terms of justification for conduct as a matter of EU law. But that's what it really comes down to, because the local authority may be starved of resources. In many cases they will be. They will be unable to, unwilling to provide anything more than assistance at the level that we've seen in this case. And thereafter it becomes effectively a budgetary struggle between the local authority fighting tooth and nail any imposition of some convention-based obligation upon it, and saying we don't have the funding to deal with this in any event. The idea that that is the remedy the CJEU accepts exists in the background and treats as sufficient to discharge the close reasoning set out in sections 92 and 93 is unreal. And that's the question. The question is that form of background theoretical relief predicated upon a burdensome, time-consuming, and with no prospects of success dispute, is that going to be sufficient to discharge the obligation identified in 92 and 93? And I go back to the point I made back in March when I was arguing this case before you. The passage in 92 and 93 has to be seen against the backdrop of the equivalent passage in Advocate General de la Tour's Advocate General opinion. It's his idea developing fundamental rights in this fashion as effectively a third answer to the problem that is picked up and run with by the court. He makes the analogy to the Chavez, Vilches, Zambrano line of case law and the individual assessment that requires. And it's that concept of individual assessment which is very plainly directed at the here and now for a particular claimant, for their particular needs, not generic needs, not the needs of PSS claimants in general, their particular needs, because they have children, because they've been in a country for a certain period of time, because this is or is not the extent of their family connection, because this is or is not the extent of their obligation, the number of children, the age of the children's developmental needs. That's the test. And the idea it can be discharged by simply pointing in the background to the existence of some extremely inchoate safety net, like the Children's Act, is unreal. That's our submission. That was the submission that we made to the Upper Tribunal and was accepted by the Upper Tribunal. And it's a submission we urge upon you again. And notwithstanding hearing this Children's Act argument developed yet further for the third time, it remains our answer to all this. What then of DSD, Munjaz and Adlard? Well, the first point, forgive me for saying it would have been helpful to have had the authorities in advance. I was somewhat surprised that my learned friend came armed with authority. But my answer to this two sets of cases is, at first level, the same as my answer to the DSD case, which is, interesting is, as the case law on Article 3 of the Convention and Positive Obligations is, it is with respect not relevant, because the relevant question is what is the test set out by the CJEU, which binds this court, and has it been discharged? This part of the case has never been run as a convention rights case.
Well, the reason it might be relevant is because certainly Mr. Coppell advanced the argument that the gravamen of the case was Article 3, degrading and inhuman treatment, not Article 1, dignity.
Yes.
And insofar as there was overlap, they were the same thing. So Article 3 is their preferred route, and that's the basis upon which they set out their second note.
We're in the same terrain of the same problem and the same rights, but the difference is that we're dealing with a test set out by the CJEU as to what the state must do in those circumstances, and that is a different test, and it's the operative test. And that's why, with respect...
It's not a system-based approach in CJEU, it's personalised.
It's personalised, and it can only be read as being personalised, and once it's read as being personalised, that's the end of the matter, with respect. But the second answer is, there is an important distinction between investigation of these topics on the plane of policy and on the plane of individual decision-making. And it's a point my Lord Justice Green picked up on by reference to Article 2. Because the Munjaz case is very much part and parcel of that raging debate about policy and the circumstances in which policy is unlawful that was finally settled by the Supreme Court in A, Eritrea, etc. And as you know, we now have A setting out one basic approach in relation to policy, but then approval of the unison approach for those human rights cases, like access to the courts or matters like that, where a real risk test is employed. And that's the operative law. Munjaz was very much an early foray into that issue and the question of how far your policy, you must have a policy, how far it must prescribe this, how perfectly must it anticipate every single problem. It's always been the case that if you present, as opposed to ab ante, as it's called in the Christian Institute case, before the human rights problem has manifested itself, if you present after the fact with concrete facts that show that you are in a position of convention right breach, that is a very different situation. And that is the situation anticipated by the reference to the Article 2 cases where the risk to life is concrete and known. That's one exception. Another exception is where you were in a situation where you can say, put my hand up, I am suffering Article 3 CIDT or a breach of Article 8 on the facts of my case. And it's that then triggers a concrete right of remedy. And that is the fact of this case. That is effectively what the CJEU is saying at 92 to 93. They are saying that you must address and identify those cases, and where they present, you must provide the remedy in question. And the remedy is that which is providable at that point in time, and the only remedy that is providable in the circumstances is the award of universal credit. Now, I should also add that this court has raised the issue, fair and square with my learned friend, about what do we do about the missing party, the local authorities. Their case is, it's all on the local authority. And that is their case at the end of the day. Their case at the end of the day is, if they don't succeed on ground four, and that the FTT and the UT haven't misunderstood the relevant operative threshold, and my client is in a position of destitution, they can nevertheless wash their hands of this issue because it is the problem of the local authority and the local authority alone, which is, on my learned friend's argument, in breach of its obligation. Now, 2 points to note about that. First, the argument is, given the indivisibility of the state, an argument of self-induced frustration, ultimately. Because if the obligation is the obligation of the state, ultimately, it does not behove the state to say, well, your rights haven't been breached because someone else has breached them. And with respect, nothing in Munjaz or Adlon answers that basic point. But the second point we would make is that if any party does want to go that far and effectively say, in relation to the breach, the only party that is answerable for it in a public law context, then they should join that party as a party who will become a necessary and proper party to the litigation. And the reason that step hasn't been taken, we don't know. I can have a fairly good stab because the local authority is likely to turn up and say, there's no way we can do this function. We don't have the budget or resource. It's impossible for us to do it. We don't have the fact-finding. We're breaking under the strain of our existing obligations. And that process will immediately show how shonky, for want of a better word, Section 17 is as a safety net. But that having not happened, with respect, we say it's really not open to the Secretary of State to make this argument to that extent, to effectively say, if there is a breach, we wash our hands of it. Their obligation is to do that which the CJEU identified in paragraph 92 and 93. And I'm not going to rehearse all the arguments about the language, the different languages. You've had my submissions in relation to that.
Can I just ask you something on Section 17?
Of course, madam.
The Secretary of State says the local authority, if AT is destitute, has a duty, not just a power, to act. My lady's already referred to authorities about within the budget. We haven't really been given very much authority on Section 17, how it operates. I mean, given the centrality of it is to this point.
Well, on its face, it is a target duty.
Yeah.
And there is quite extensive case law, I think, on how that target duty is operated and discharged. And of course, in a similar but different context recently, this court has spoken on the subject of target duties in the context of the national health.
Yeah.
The judgment in July in the AA against NHS England case. And that has reinforced just how wide target duties can be, and how, notwithstanding apparently clear language, nevertheless it's impossible to mine them for concrete obligations.
So you don't accept the Secretary of State's argument that the power has converted or can convert into a duty in this case?
Well, I don't think I need to go so far as to say that it can never happen. All I think I need to say, and all that is necessary for my argument, is that that is an extremely difficult process involving many steps and contested litigation, etc., before there is any prospect of any result. And it's that is the primary obstacle from the perspective of effectiveness of remedial protection. Because if the remedy is potentially obtainable, but 2 or 3 years down the line, after a long and bitter fight with legal aid, the damage is done. The damage is done from the perspective of the child's development, the circumstances in which they've been expected to live. It's not a remedy at all.
Absent interim relief.
What?
Absent interim relief.
Absent interim relief. And
It slightly goes against one of the fundamental tenets of the Children Act. I think it's Section 1.5. Delay is inimitable to the welfare of a child.
yes, and that's why in the CJU's judgment, I think it's round about paragraph 89, they lay so much emphasis on Article 24.2 of the Charter, which is in pretty much the exact same terms as the language of the UN Convention on the Rights of the Child. All of this immediacy of relief and effectiveness of relief is grounded in the child's interests, and that's one of the pivotal facts in the
It's grounded not only in the child's interest, but I mean, dignity, according to the CJEU, just simply applies. You're entitled to it when there's a risk that it doesn't exist. Mother, child, male immigrant, whoever, whatever.
Absolutely. I mean, the relevant passage, we'll pull it up, is it's 90 and 91. I said 89. I misspoke. Furthermore, Article 7 of the Charter recognises the right to respect for private and family life. The article must be read in conjunction with the obligation to take into consideration in all acts relating to children the best interests of the child, which are recognised in Article 24.2 thereof. See SM Algeria. The host member state is required to permit children who are particularly vulnerable to stay in dignified conditions with the parent or the parents responsible. That's pretty much the central reasoning of the court as to why there's a requirement for an individuated assessment in this case. And of course, the best interests of the child are also correlative with the interest of living in dignity of the mother or the parent with care, because nothing is more humiliating or demeaning than being required to bring your child up in conditions of poverty. It's not just a cost for the child, it's a cost for the parent as well. So that's the circumstance. And the idea that the CJEU, which is concerned time and time again with the substance of protection, not form, would propound this test and then say it's satisfied by the idea that you might get legal aid to bring a judicial review against a local authority that might generate some interim relief and eventually a finding in circumstances where the alternative is a potentially temporary award of universal credit whilst the position is sorted out between the local authority and the Secretary of State directly. That's unreal. That's unreal. So, unless there's anything else I can assist you with further.
Thank you, Mr. Delamere.
Great.
Nothing from me, my lady. You'll have seen the court knows that we intervened, the IMA
Yes.
intervened on ground one. We've
Yes.
said what we've said in writing, unless I can assist.
No.
I don't have anything to...
No, well, we're grateful for your attendance today in any event. Thank you very much.
My lady, two very short points
Yes, of
on
course.
behalf of the Air Centre. Firstly, echoing what my learned friend Mr Delamere has said about Section 17, we would just urge this court not to venture too far into the very difficult and complex questions around the content of that duty in certain circumstances. As has been pointed out, the local authority is not here. It is a very important duty in some cases, and some claimants do rely on it successfully to bring claims, and it would be, in my submission, undesirable for this court in a case where the local authority is not before it, to say very much at all about what the local authority ought to have done or might have been compelled to do in this case, had litigation been brought by AT, when all of the difficulties in relation to that litigation have already been so eloquently expressed to you by my learned friend Mr Delamere. So the difficulty with Section 17 is enforceability. As well as the various arguments that may be raised by local authorities in their defence. Secondly, just to pick up on a point that's been made in the correspondence leading up to this hearing, as the Air Centre said in its evidence, there are a number of cases continuing to come before it, clients continuing to present to it, who this case will directly affect. So it's really just a plea to the court that the new draft judgment be circulated as soon as is reasonably possible, of course, recognising all the other pressures on your lord, my lady and my lords.
Anything else? No? No, thank you very much. Anything in response?
Just three extremely short points. First one is Mr. de la Mare suggested there was a gap where children weren't involved and the Children Act wouldn't apply. For obvious reasons, we were trying to focus our submissions on this case, but as we set out in our further note, potentially Section 1 of the Localism Act, General Power of Competence, might be available in such a case. But the obvious, this court is focused on this particular case, and we cannot be criticised for not going sufficiently into other cases.
But you've referred to the Localism Act in your supplementary submissions.
Yes.
So, in a sense, it's on the table.
It's on the table.
It's a very broad power, which isn't specifically addressing homelessness or housing. And indeed, in regulations, the Secretary of State expressly excluded housing and homelessness. So it's difficult to see how, in those circumstances, a local authority could be criticised for not using the Localism Act.
Yeah, I was just highlighting that it's not. There are other tools available if there aren't children involved.
Okay.
Second, very quick point. There's a difference of understanding as to what the court is saying at paragraphs 92 to 93 of CG. We say the court is precisely inviting the relevant decision-making body of the member state to look at the other forms of support that are available under the domestic system. And that's entirely in line with what we're saying. Mr. de la Mare takes a different view, but you have our submissions on that. Final point is, Mr. de la Mare's case really boils down to the adequacy of judicial review. And we would submit that is his case is extremely ambitious on that point. Judicial review is there. It's a flexible system. Unlike the tribunal, interim relief can be provided. Where convention or charter rights are engaged, the court will have to engage in a more substantive analysis than it would if it was applying conventional common law, public law principles. It will have to make its own substantive finding as to whether or not there would be breach. So in our submission, the weaknesses and inadequacies of judicial review are overstated by Mr. de la Mare, and they were points that were understood, for example, by the Supreme Court in HC, and that didn't deflect the Supreme Court from its view in relation to the availability of judicial review. May I just quickly check with us?
Of course you may. Just remind us if HC is in the bundle.
It is. It's at, sorry, let me get the reference. It's at tab 47.
Thank you.
Paragraphs 33 to 37 and 43 to 46 are the relevant ones, pages 1253 through to 1257.
Thank you very much, that's most helpful.
My lady, I haven't addressed it because it's addressed in our skeleton argument.
Yes.
I didn't want to repeat our submission.
Yes. No, well, thank you all very much indeed. Thank you all for making yourself available. I know how very difficult it is when a case has moved on forever and to get together again to deal with these matters. We found it extremely helpful. We're very conscious of the significance and importance of this case. I think, certainly speaking for myself, I found the additional submissions most helpful. As you know, you've already had a first draft. You will now receive a second amended draft. So if I can...
2 p.m. this afternoon. Not.
As you say, it's not a secret in this particular case who is lead on the matter. So I'm sure Lord Justice Green will endeavour to get it out as quickly as possible. We are conscious that there are other cases awaiting our draft in this matter. Normal rules apply so far as the draft is concerned. Typographical and minor implicities only. I think we've all had an opportunity of adding extra submissions, so we don't need any more submissions or further argument in the light of our draft. Please just remind everyone involved, this usually falls to the solicitors and junior counsel, of the terms of the embargo. In a case like this, it's extremely important that a draft that may not have been finalised is not distributed or seen by those people that should not have a sight of it yet. So apart from that, unless there's anything else anyone would like to bring to our attention, we'd hope that anything else that may be dealt with in writing, by which I mean matters such as costs and not any further submissions. Thank you all very much indeed.
Court is available. So it was